We'll continue with the conference here on the panel on multiple systems, standards, and dilemmas. My name is Kirk Williams. I am a professor of criminology, law, and society here at UCI. I'm in the Department of Criminology, Law, and Society, which is situated in the School of Social Ecology. This is actually my first year at this university, and I have just completed teaching a course on domestic violence, which to my understanding is the first time that that course has been taught on the campus. I'm teaching it again this quarter. Had 110 students last quarter, 110 students this quarter, so it's obviously a very, very important issue that our students are very much concerned about. But this panel is not about me. This panel is about our featured speakers here. And we will go in the order as listed in the program. And so our first presentation is Elisa Bieria and Colby Lintz, and the title of their presentation is Judicial Fictions, Maneuvering Agency in Failure to Protect.
Thank you. Thank you so much. We changed the title a little bit. We decided to zero in on a couple of specific points. So the new title is up on the screen. We want to thank Jane so much for inviting us, and Stacy and the whole UCI team for the conference. It's been really wonderful. Okay, so researchers have noted that women who are survivors of abuse are more likely to be criminalized and incarcerated, and that the majority of people in women's prisons have experienced domestic and/or sexual violence before incarceration. Survivors become targets of policing and prosecution in part because survival action is often criminalized action, including survival strategies such as self-defense, migration to a safer location, or avoiding violence through coerced illegal activity. Domestic violence survivors are also blamed and prosecuted as a consequence of batterers' violence against their children through failure to protect laws, or laws that punish survivors for failing to prevent the abuse of children. Failure to protect convictions disproportionately punish mothers. Relatively few men have been convicted for this particular offense. As a strategy, defense attorneys have argued that domestic violence is a, quote, mitigating factor that should be taken into account, which is an attempt to provide explanatory context for the failure, while the premise that the survivor failed at all remains unchallenged. Considering two case studies, we argue that mitigating factors approach is ultimately ineffective as a long-term defense for those charged with failure to protect. It ignores the political implications of prosecuting survivors for failing to control their abusers, essentially, and obscures what Beth Ritchie has called the matrix of violence, or complex systems of battering in which courts, among other carceral systems, are entangled and implicated. Colby and I propose battering court syndrome as an alternative model that directly critiques the violent coupling or transference of culpability from batterer to survivor. The model clarifies multiple carceral relations between courts and batterers, and it foregrounds judicial agency, including its role in institutionalizing domestic violence. Beth Ritchie has argued for a more comprehensive understanding of violence against Black women that contextualizes their experience of domestic and sexual violence within structures of state violence. The matrix here, we see this here on the PowerPoint. It defines the multidimensionality of violence by proposing a topology of categories of violence here on the horizontal line, and agents of violence on the vertical line, helping us map the nodes of connection across these category cells, which is what she calls them. Ritchie argues that a Black feminist analytical approach to the matrix of violence, quote, demands a more rigorous and in-depth analysis of how state institutions and neoliberal public policies interact with and deepen the harm caused by household and community violence, end quote. We're particularly interested in how domestic violence unfolds within nodes of connection between intimate households and state cells. Rather than invoking the context of domestic and state violence as a mitigating factor that further explains actions, survivors' actions, we propose analyzing how domestic and state violence are actually part of the matrix of violence that connects the actions of batterers and state actors through multiple kinds of dialectics. or carceral relations.
So to do this, we're going to look at two case studies today as illustrations of nodes of connection between courts and battering in the context of failure to protect cases. We're looking at the case of Kelly Ann Savage, who is at the time of arrest, was a poor working class white woman in the Central Valley in California. She's still in the Central Valley. And then Tondalao Paul, who's in Oklahoma. She is also, at the time of arrest, poor working class black woman. So first, to talk about Kelly's case. Kelly Savage is a domestic violence survivor serving her 22nd year in California prison. Her abusive husband in 1995 killed her 4-year-old son, Justin, after she put her children to sleep and left the house to run errands in preparation to escape with her children the next day. Kelly was not present when her son died, but the district attorney blamed her for not escaping and saving her children sooner, ignoring the documented dangers associated with attempts to leave an abusive partner. Expert testimony about Kelly's abuse was not allowed in her trial between 1995 and 1998, severely harming her defense. Kelly's own lawyer and trial judge fought her request for a domestic violence expert who could have testified on her behalf. She was convicted of first-degree murder for, quote, aiding and abetting her abusive husband and sentenced to life without possibility of parole. So just to drive that in, she did not harm her child and she's serving life without parole. While Kelly was not convicted under California's failure to protect statute, her conviction relied heavily on a failure to protect logic that blames mothers for the violent action of their batterers. So in 2002, California passed legislation that gave some convicted domestic violence survivors the right to submit a petition for a writ of habeas corpus challenging their original conviction, potentially releasing them from prison. So this is California Penal Code 1473.5. This habeas law allowed Kelly to petition for a review of her conviction by permitting the submission of expert testimony about her abuse, which was not allowed in her trial. To defeat the petition, the prosecution's strategy was to establish Kelly's direct culpability for her child's death, despite the newly introduced domestic violence evidence. A review of arguments used to sustain Kelly's conviction can help illuminate how the relationship between courts and battering unfolds. So first, the prosecution disregards the 2004 amendment to the law that specifically broadens eligible convictions to all violent felonies. So first, the law was written only to allow post-conviction appeals by women who killed their batterers in self-defense. So second, the judge reinforces rather than corrects this error, refusing to apply the habeas law to a survivor prosecuted as a consequence of her batterer murdering her child. 3, the prosecution exploits any sign of Kelly's capacity for agentic action, presumably including her attempt to escape, as an argument that she is guilty of murder. So this is all just happening recently in the last couple of years in Kelly's appeal. 4, despite the fact that the point of the hearing is to correct the suppression of domestic violence expert testimony, the prosecution grossly minimizes any relevance of domestic violence, asserting that some laws have a who cares position about the abuse. So was she abused? Yes, even the prosecutor admitted that, but at some point we have to say, who cares? 5, the judge expands his causation view of violence to argue for Kelly's culpability despite little credible evidence, while narrowing his characterization of the batterer's role in causing the child's death. The judge said, the beating might have been a final act of abuse, even though there was no evidence of Kelly doing anything to abuse her child. So the intent of the habeas law was to correct the injustice that domestic violence evidence and expert testimony was historically repressed or omitted in prosecuting survivors. The law states, quote, if the competent and substantial expert testimony had been presented, there was a reasonable probability sufficient to undermine confidence in the judgment of conviction or sentence that the result of the proceedings would have been different, unquote. There are 2 ways to interpret the corrective scope of the habeas law, in our opinion. In part because of the legacy of the, quote, mitigating factors or partial defense model of battered woman syndrome and other trauma-based defenses, one can interpret that the law is only meant to consider if domestic violence evidence can be understood as mitigating the action of survivors. We see this as a restrictive interpretation of the statute that projects constraints onto the law that are not there. They simply do not exist in the language of the law. Alternatively, we submit that there should be a structural interpretation of the law's corrective scope and that the statute indicates that the suppression of crucial evidence could, quote, shake the confidence of the judgment, which can include ways in which the evidence challenges the legitimacy of multiple elements of the trial itself, including procedural and structural issues. So for example, we see the suppression of domestic violence evidence limits or blocks the survivor's right to procedural due process in the first place, which weakens the legitimacy of the trial itself. We see that the suppression transforms the context in which all trial evidence and arguments are considered, and therefore the jury's and judges' understanding of the role of that evidence in competing trial narratives. And we see that the suppression undercuts the credibility of testimony, including witnesses who may have testified without knowing the context of domestic violence, the survivor who may have been threatened into providing responses advantageous to the batterer, and the batterer who may have been using the trial as an extension of his climate of punishment and threats. And lastly, given that the failure to protect has been evaluated as biased against women in particular, the lack of domestic violence evidence establishes a potential problem of institutional gender and potentially racial bias of all court actors, including defense attorneys, prosecutors, judges, juries. And then our second case study is Tondalao Hall. Tondalao is a domestic violence survivor serving her 13th year in Oklahoma prison. Prosecutors charged Tondalao with failing to protect her 3-year-old daughter from her boyfriend's abusive acts, presenting no evidence to the court that she harmed her child in any way. Tondalao testified in court about the physical abuse she suffered at the hands of her boyfriend, but she revealed in her commutation application post-conviction that she was not fully candid in her court testimony because she was repeatedly threatened by her boyfriend as they were transported in a van together from jail to court proceedings, despite Tondalao begging for that to stop. Tondalao's sentencing judge stated on the record that she seemed scared of her boyfriend while testifying, but the judge used that information as reason to argue that she should be punished for lying. Tondalao's boyfriend took his case to trial and ultimately pled guilty to a lesser charge. He was sentenced to 10 years in prison, but his sentence was suspended and he was released with 2 years' time served. The prosecutor further blamed Tondalao for their inability to sentence her boyfriend for longer, and also blamed her for quote-unquote lying about the lack of domestic violence on the witness stand, even though she did that because she was being actively threatened by her batterer. The prosecutor also argued that as the child's mother, Tondalao was the most culpable and the most criminal. Through the exploitation of her identity as a domestic violence survivor and a mother, Tondalao was sentenced to 30 years in prison. So in our opinion, just a quick summary of what we see as the judicial collusion between Tondalao's batterer and the court in her proceedings. The judge and prosecution invent and assign criminal intent to Tondalao based on their perception of her affect on the witness stand in the courtroom. The judge and prosecution couple and conflate survivor and batterer culpability. Tondalao is seen as, quote, just as guilty. The prosecution inflates Tondalao's culpability based on gendered expectations of mothers and mothering. The prosecution blames and punishes her for their failure to secure a longer sentence for her batterer. They use their perception of the batterer intimidating Tondalao while she's on the stand as proof that she is lying and should therefore be further punished. And they exploit the history of domestic violence victimization as a strategy to establish the victim's guilt. Consequently, her defense attempts to suppress domestic violence history to avoid a guilty charge in order to not have her sentenced.
Okay, so a structural interpretation clarifies how the omission of domestic violence evidence does not merely limit a more complete understanding of why survivors act, but creates a system of collusion between courts and batterers that institutionally validates the blaming and punishment of survivors through establishing court narratives that have very little to do with reality. So here's our working definition. There you go. Judicial collusion, battering court syndrome, BCS. When you put the letters there, it makes it more official. Judicial collusion with batterers through the criminalization of survivors of domestic violence. It creates a spatial continuity of violence between domestic space and court space. It also establishes a bureaucracy of battering that officiates domestic violence through ongoing violent punishment of survivors. BCS affirms the principles of battering as institutionally valid. And some examples of those battering principles are below. Survivors don't have the right to self-defense. They're inseparable from batterers and should be blamed for batterers' actions, should be punished for not satisfying racialized gendered expectations, etc. Sorry, I hope you can read that. So we identified some carceral relations between courts and batterers to kind of tease out more what batterers court syndrome is all about. And we could see some of these things play out in Tondalao's and Kelly's cases. So judicial fiction, in other words, stretching the truth to defend the absurd coupling or transference of culpability from batterer to victim, and the distortion of laws to make sure that the survivor is prosecuted. There's a carceral pipeline. I'm sure folks have heard of a prison pipeline, but we want to make sure that the entire parts, all the parts of the carceral system are identified in terms of survivors moving from gender violence to prosecution. That pipeline is bidirectional, and pipeline goes from prosecution to prison, sentencing survivors to a third site of pervasive violence. In fact, Tondalao is incarcerated, let's see here, right, at Mabel Bassett Correctional Center, which has the highest rate of rape of women's prisons in the United States. So you can see the ways in which this continues to create more violence. Courts mirror patterns of domestic violence. Many survivors of domestic violence have said this again and again about the ways in which prisons and police and courts use isolation, stigma, punitivity, no control, et cetera, et cetera. There's something very familiar about the ways in which these systems treat survivors. Manipulative culpability, it's your fault that I do this, a coupling of agency. And lastly, courts adjudicate women based on racialized gender expectations by treating perceived failure to protect as transgressive to normative femininity and motherhood, and thus extra punishable. So it doesn't just conflate culpability, it inflates culpability.
And just real quick, because we are out of time, in terms of recommendations, we obviously are recommending that we consider a battering court syndrome. We're recommending that we think more critically across scholarly, academic circles and analysis about court violence in particular as a key site of criminalization for survivors. And let's see, I'm going to skip over most of these things. We also want to talk about trying to build more coalitions between children's advocates groups and adult survivor advocate groups so that we can work together to decriminalize the survival of children and adults. Do you want to say anything about that?
Well, just one quick thing about the decriminalizing coalitions between children's advocacy and adult survivor advocacy. How many of y'all have heard of Brescia Meadows? Okay, a few. So she's a young girl, a black girl in Ohio, yeah, who killed her father. Her father was extremely abusive to her family for years. And she killed him in an effort to defend herself. She tried to access support from various systems, including police, who all turned her away. And so then she was arrested, and she's in juvenile detention, facing a trial next month. So that case really illustrates the reason why it's important to tie children's advocacy with adult survivor advocacy. There's so many connections there, but what we have seen is that these two things are constantly presented to us as oppositional, which is a problem and not really responsive to the reality of the situation. So, so we need to figure out what those coalitions really look like.
And lastly, we're going to leave you with a slide with resources. So we're both a part of a group organizing project called Survived and Punished. I work with the California Coalition for Women Prisoners, and there are campaigns to free both Tondalao Hall and Kelly Savage. We have the links there, and you're welcome to come and talk to us afterwards. Thank you very much, and we would appreciate any feedback. There won't be time for Q&A, I hear, but if people want to come talk to us afterwards, that would be great. Thank you.
Thanks.
Okay. Thank you very much. Our next presenter is Cynthia Godso, who is presenting on rethinking parental prerogatives.
Great. So I think, do I just do this? Okay, great. So thanks to Jane and all the organizers. This has been great, and I feel like I've already learned so much. I want to continue sort of talking about this intersectionality or type of intersectionality between children and parents, although I'm really focusing largely on parent violence against children, but that's not to say that I don't see that there's a lot of synergies there too. What I'm really talking about is a particular kind of parental violence that I think really goes largely unnoticed and even unquestioned, which is the parental discipline privilege or parental corporal punishment. So, of course, it's mostly, or a lot of legal scholars and lawyers have to talk about Blackstone, but in all his sort of famous exceptions to assault rules hundreds of years ago, which included a parent or children, scholars or students, apprentices, and then, of course, wives. The only one that remains, a categorical status exception in every single state, is parents over children. So parents are allowed to physically discipline their children in every single state. Something that I, as a criminal law professor and a former lawyer for children and abuse and neglect and a parent myself, was sort of surprised by the extent that it still exists and still really goes unquestioned. So courts continue to cite Blackstone. Courts continue to cite cases that predated the Civil War to justify this and to determine how much is allowed. And as I'll talk about in a minute, a lot is allowed. So going back to something Michelle Goodwin said in her video about marital rape, I mean, this is an area that there's a categorical, the only remaining categorical status exception to a violent crime that really goes virtually unquestioned, right? This is an exception to assault. It's a complete justification, which in criminal law terms means it's a total forgiveness, like that your act wasn't even wrongful in the first place. Okay, so let's parse out what that means. Oh, just to show you, so in every state, and then here's the states permitting pets, like the majority of states are permitting pets to be included in protective orders. And I show this not to minimize, as many of you, as all of you know, and as many of you have discussed, obviously there's huge problems still in the prevention or treatment of, or prosecution of intimate partner violence, but it's just to show that in every single state on the books, we're not even talking enforcement problems, on the books, this is a complete justification if parents are using assault, basically, what would otherwise be assault, to physically discipline their children. And I put up here the language from the Model Penal Code, which is supposed to be what, the model for what our criminal law should look like, and usually is taken for that. And we're not talking spanking. So spanking is really a misnomer. Every state allows more than spanking. California has one of the most restrictive, actually, and even it allows a bit more than spanking. But many states allow force used up to force that does not create a substantial risk of causing death, serious bodily injury, disfigurement, extreme pain or mental distress, or gross degradation. Right? So you're allowed to do anything but these extreme things. Again, a lot more than spanking. So what are we talking about? We're talking about beating, and again, this is allowed in most states, beating with a belt or wooden spoon or a paddle, hair pulling, face slapping, pinching, choking. I mean, again, not spanking. That's not what we're talking about. We're talking about a lot more severe things here. And there's, there's a lot more that you could add on to this that's commonly in the case law excused. And then in terms of who can assert it, also extremely, extremely broad. So a much broader definition of parents than in any other area of criminal or family law. And I say, so for instance, I think it's 32 states allow foster parents who otherwise really have no legal rights over the children in their care because, I mean, whether you agree with that or not, that's the way they've been, they are treated in all other arenas, like they can't sign for medical treatment and so on. A majority of states allow custodians and also persons in local parentis. So basically, the mother's boyfriend, standard example, just to generalize, but that is a very common defendant in these cases. So the mother's boyfriend who doesn't have any legal obligations to the child for child support or anything else, and actually no legal right to make any decisions for the child, and yet still is allowed to assert this parental discipline privilege. And I point this out just because it shows how entrenched this is, that basically any adult who has caregiving responsibility for a child practically is allowed to assert this and allowed to do things that if a stranger did to a child or if a paid caregiver would be a serious assault charge. I also wanted to point out that in terms of other criminal laws, the definition of parent is much smaller. So for instance, so here we're talking about exculpation. People get forgiven for this assault if they're a parent figure in any sort of very loose sense of the term, not at all, much broader than legal parents. And yet in terms of incest, if we're talking about adult incest laws, much, much narrower. Very few of these people would be included except for biological parents, not even necessarily adoptive parents in a lot of states. So someone has the right to, I always use the Woody Allen example. So he had the right, he would have had the right to severely corporally punish Sun Yi, who he basically helped raise under New York law, but then he was not at all subject to prosecution for incest when he had sex with her when she was a very young adult, as he would have been if he was her biological father. So here we're giving rights to people over children, but they don't have any kind of the same responsibilities as other parents do. So as Jane has said about other things, like the evidence is in, about corporal punishment. It's now absolutely pretty much unanimous across the board that even relatively mild corporal punishment causes harms. Well, first of all, that it's definitely ineffective, right? So the argument that it actually helps, definitely ineffective. Pretty much all experts agree. So there have been so many studies, but then last year a meta-analysis of over 100 studies found no evidence that it improves behavior, and actually it's correlated with increased risk of basically everything: antisocial behavior, mental health problems, cognitive outcomes. Specifically for this audience, it is highly correlated with future violence, both as a parent and then as an intimate partner, right? So that's what you're learning as a child, and then you grow up and you perpetuate it. And studies of when it crosses over the line into physical abuse, which is quite severe given how much corporal punishment we forgive as not assault, but that a majority of these cases, of abuse cases, began in the family as ordinary corporal punishment that escalated, right? So it's not that these are two totally separate things. They come from the same place, which is, sort of parental control over and frustration and anger with, and this is the way they're expressing it, and so it definitely elides into severe abuse, including, homicides of children. And again, experts have been pretty clear on this for a long time. So the American Academy of Pediatrics issued a statement as long ago as 1998. Although, there is some political pushback in terms of actually doing anything about it, but there's very clear evidence of the harms. There's additional personhood harms that I'll talk a little bit about, but in terms of empirical evidence, it's just absolutely clear that this is not an effective disciplinary method, and also that it, brings a lot of harms. So why do we continue to allow it? I mean, basically, there's really no real rationales except for these kind of myths people talked about in the gun violence context. These myths, sort of history, and then also these myths that, this is what I had as a child, or this is what I think, parenthood should do. So, experts online will say things like, I don't care what the experts, or I don't care what proponents online, will say, I don't care what the experts say. Some kids need a period. When timeout talking and taking away toys doesn't work, you have to get that butt. I mean, these are, these aren't just like random people. These are experts in like magazines and media. There's basically no legislative, so I said it exists in every state, mostly by statute, sometimes in case law. There's no real rationales offered in most of them. They just sort of say parents have the right to do this. And there's no real rationales, no accommodation of the empirics. A lot of people use the biblical passage, and I'll talk a little bit about disproportionate use in different communities, which includes evangelical Christians. Apparently this is like a misquoted passage anyway. It did not actually refer to hitting people. It referred to a shepherd guiding, like with his rod, like showing the way, which might be better parenting strategy. But people misquote it. And the unfortunate thing is it's not just proponents, it's judges, right? So there was an Indiana case where a judge acquitted a father of choking his teenage daughter. I think she convicted him on a very minor misdemeanor charge, but he had choked her and also caused other severe injuries because she had, disregarded his rules about the cell phone. And she said, I totally understand why you're as angry as you were and why you did what you did, because I am assuming you're trying to prevent her from living a life you don't want her to live. And again, she convicted him, the judge was a woman, convicted him on the most minor charge, acquitted him on a lot of serious harm, like the choking. And she said, unfortunately, I think we're in this universe now where parents don't just get to do whatever they want, right? So it's like they can do almost whatever they want, but I have to give you a little bit of a charge. So again, even judges buying into this, not looking at the data, not looking at the language of the, choking statute, not looking at other things, and just saying, assuming that the parent is trying to do his best and trying to keep his children's best interests in mind. In terms of different communities, so first of all, when we talk about politicization of safety, I mean, there's a significant gap in opinions, and this is also true of prevalence, but this was just opinions, but it closely tracks also use, which is there's a big partisan gap and a big religious gap on what people think about the appropriateness of corporal punishment. There is also a pretty significant regional gap and then a racial gap. And actually, there's a book that came out just in the last few weeks. I think the author, Stacey Patton, has something in the Washington Post today. She's had a lot of press over it. It's really interesting. I'm in the middle of reading it right now. But basically, there is a disproportionate use or approval of it in the African American community. She attributes some of this to slavery and lessons learned about sort of submission and obedience, and then talks about how there are person-centered harms and even additional person-centered harms for children of color. Now, my point is not to say that everything she concludes is correct. I don't really know enough, but to say that there is a connection, just as there is with intimate partner violence, between what goes on in the household and larger structural inequalities and power dynamics in society. So her argument is that we're teaching Black children that the only way that they can be controlled, particularly Black boys, is by violence, that they have to be blindly obedient, and that has resonance for their roles in the future or their behavior in the future as adults in society. Okay, so one thing in particular that I think is particularly problematic also about, again, these laws on the books, not even enforcement, is that most of them, the mens rea for criminal purposes, is you generally have to show that it's reasonable, but again, that, as I said, that allows a huge amount of, it's reasonable apparently to hit your child with a paddle or to choke them, et cetera, as long as it's for their welfare. So most of the laws have some language in it that the parent reasonably believes it's necessary to prevent or punish the misconduct or that they're promoting the welfare of the child, but this basically is usually rubber stamped. There's many, the case I was talking about with the paddle, the father was cursing and screaming at, or a case where a father beat his 10-year-old with a paddle for not eating his dinner. He was cursing and screaming, apparently. The judge found that to be reasonable because, of course, the father cares for his child. And I think a lot of this comes back to these assumptions that we used to make in the marital context or in the intimate partner context, and still sometimes do, that, of course, there's love here, and this was just a mistake, or this is, maybe they're a little misguided or went a little overboard, but it's really done out of love, when in reality, if there's so much evidence that it's harmful, and if someone's expressing so much anger when they are essentially assaulting someone else, how can we really say that this is for the welfare of the victim, right? It makes it kind of worse that we're excusing it as, well, it's really in his or her, the child's own interest. So, why do I think it has continued for so long when we actually have made, some progress, although we have a long way to go in the adult context? And just as a note, the thing on the right comes from like a parents' rights organization, right? So parents' rights advocates, great, and I'm not, I'm certainly not against parental rights. I think that parents need to have rights on both a personal and political level, but I mean, it's interesting, again, that this is seen to be an act of parental love, right? Like, make sure it ends in tears. That's how they're going to learn that this is wrong. Why do I think it's continued? I think part of it is it's really not recognized as harm. We think of it as spanking until you start to really dig through the cases and the statutes and figure out, like, actually it's much, much more than spanking. That it's largely out of sight, out of mind. So some of the cases even seem to say, well, this parent did this at school or on the street, so that matters, but implying that if they did it in the home, maybe that would be okay. So again, this notion of the private-public line, which just hasn't moved as far in parenthood as it has in the intimate partner relationship or in the intimate partner context. There's a lot of other countries, so actually now up to France just did earlier this year, 52 now Western countries have banned corporal punishment. There was a call by Obama's Secretary of Education in December to ban it in all schools. It is banned in a majority of states, citing a lot of the same data, and it's banned in daycares, prisons, et cetera. So why do we still allow it in this context? I think is a really important question that we're not asking enough. There are definitely costs. So as a former defense attorney, I'm definitely, the critiques of the carceral system that many of you presented definitely resonate with me. So I don't necessarily think criminalizing prosecuting parents for assault is the right answer, but I think there are other ways to communicate it rather than continually forgiving, this extreme level of intrafamilial violence. So I guess I'll stop there. Thanks.
Thank you, Cynthia. Our next presenter is Amy Magnus, and she's presenting on Crossed Over or Crossed Out, a critical assessment of specialized juvenile and family justice initiatives.
Okay, well, I'll just keep talking. Hello, thank you for having me. It's really great to be part of this conversation broadly at the conference, but also on this panel as well. My research is taking things a little bit further in terms of the institutional effects of what we see in interpersonal violence, family violence, and the relationship of multi-system involvement. So I'd like to talk a little bit more about that today. First, I'm going to be talking about my ongoing research project that I haven't really gotten any official or conclusive findings from, but that I want to talk a little bit about my methodology and my theoretical framework as it might be helpful to others, as well as the future of my project. So first, like I said, I'll discuss the theoretical framework and the methodologies, and then also my preliminary and exploratory findings from this project thus far. So I situate my project and my thinking about specialized justice initiatives broadly within a number of theoretical and conceptual frameworks. I do this because of my interests in the historical contexts of socializing and humanizing law and justice, and what this has looked like on the ground throughout the last century. I'm also interested in the ways it expresses itself in contemporary society. So for this particular project, I focus on specialized courts that oversee youth and families who are involved with multiple state systems, namely juvenile delinquency and dependency. The term specialized justice allows me to think through a number of theoretical questions about both specialization and justice. In what ways are people supposed to be able to access justice, receive services from a legal system that was not originally designed to arrange or administer social services or to restore their lives or involvement with the criminal justice system? From this, I began wondering about the use of the master's tools, so to say, in trying to use mechanisms embedded within a justice system that is not necessarily designed for these purposes. Can an expansion of the criminal justice apparatus, or rather a specialized justice system embedded within the already existing system, get at the complexities and intersections of poverty, welfare, homelessness, deficiencies in education, and other forms of social inequality that underlie so much of why these youth and their families are in the courts in the first place? So this leads me to the so what that drives my project. I ask, what are the theoretical and ground level consequences for implementing specialized justice initiatives? The empirical question remains, to what extent are these initiatives truly channeling principles of access to justice, therapeutic jurisprudence, and restorative justice? And simultaneously, to what extent are these initiatives expanding state power, surveillance, social control, and the carceral net through a deepening of system involvement, with the justification of providing social services to people in need? So what I set out to do in my current research is see how this is played out in the areas of juvenile and family justice initiatives. How did specialized subsets of law and justice come to be, and why? How have they transformed throughout the last century, and what was the impetus for developing a court of all things to intervene in the lives of youth and their families? Finally, what do these courts look like today? And do they resemble the original juvenile court in 1899 Chicago, or are they doing something different? These were all points of inquiry that piqued my interest at the outset of this project. The convergence of youth and the American court system has long-standing roots in the child-saving movement and the larger juvenile justice system. The child-saving movement as a philosophy focused almost exclusively on wayward youth, especially young men and women of color, who without early intervention were perceived as bound for a life of deviance and delinquency, a future problem for American society that needed preventative treatment before things got out of hand. With the development of a formal juvenile justice system in the late 1800s, troublesome youth began entering formal courts, receiving punishments for their wrongdoings, and repaying society for their actions via detention time and community service. This was to regulate the erratic treatment of youth before this time period. And in this move, though, issues that might be informally handled at home or within the family became the formal business of the criminal justice system. And so emerged a special group of children and families who needed state intervention. I had mentioned earlier that I was interested in how the history of this contributed to what these initiatives look like today. One clear path that I've noticed in my research is hybrid court models, which has materialized as the expansion of specialized courts that hone in on multi-system involvement or multiple social issues. For example, drug courts are increasingly merging with mental health courts to provide particular services for overlapping experiences. However, the story becomes complicated when considering youth who are involved with multiple state systems. My project aims to understand the overlap between delinquency and dependency, or the child welfare system. And youth involved with both of these systems are commonly called crossover youth or dual-involved youth. There are approximately 2 million children in the United States who formally qualify for dual adjudication as a crossover youth. The temporal ordering of system involvement points to the child welfare system coming first in the child's life, but this is not always the case. Regardless of youth's entry points into both systems, crossover youth have been found to have a heightened risk of mental illness, substance abuse, teen pregnancy and parenting, and long-term adult criminality. Approximately half of juveniles in foster care have been arrested at least once, yet these youth are often overlooked in our focus on social control. They warrant greater attention in part because the long-term consequences of dual involvement are now being used as justification for creating specialized courts that are designed to address crossover status. Views regarding specialized courts in general are divided and often blurred, such that some scholars and practitioners argue in favor of their usefulness in addressing unique issues that the criminal and civil justice systems are ill-equipped to handle. On the contrary, specialized courts such as juvenile courts can be seen as a way to perpetuate the child-saving movement and a culture of control over particular youth and families. Again, I perceive this as an empirical question that does need to be explored further. There are various known characteristics and collateral consequences of long-term dual involvement in the child welfare and juvenile justice systems, as I just mentioned. The common thread for crossover youth is foster care, and further poor treatment, multiple home placements, and lacking strong familial and friendship bonds while in the foster care system. These have all been linked to youth's interactions with the juvenile justice system. And combined with this, older foster care youths tend to exhibit more apparent symptoms of mental illness and the other symptoms that I previously described. Youth involved in both the child welfare system and juvenile justice systems are at an increased risk for incarceration as an adult for serious and violent offenses, and procedurally, they are often significantly disadvantaged in juvenile courts with regard to representation and court processing. So in light of this knowledge, specialized courts have been created to address the specific population of youth and families. They are run on a platform of preventing these long-term outcomes I've just described by providing access to social services, including therapy, inpatient mental health treatment, and additional education programming, which are often called wraparound services. As I've previously noted, I'm interested in the historical backdrop of these initiatives, but also the contemporary manifestations of that history. Much of the research in this area focuses on those long-term consequences of multi-system involvement, and while this is interesting and important for my research, I perceive there to be more to the story. And this leads me to the Project One philosophy and the one family, one judge philosophy that is implemented within crossover courts across the United States. I'd like to read this philosophy aloud, drawing your attention to a few key points. Central to Project One is a holistic view of individuals and families, a life course perspective on human development and focus on ensuring equal and coordinated access to justice regardless of presenting issues. A steering committee of NCJ-FCJ members and judges has been convened to lead the initiative with the NCJ-FCJ staff and develop a roadmap for its success. One of the initiative's goals will be to develop and share resources for innovative practices across the country where the courts effectively demonstrate multi-court collaboration in practice. So the parts of the philosophy highlighted in black reflect similar progressive era rhetoric to early initiatives towards specializing and socializing justice for youth and their families. And so I'm going to move on just a little bit quicker since I'm running out of time, but I wanted to share a map of where these courts are located. So currently 6 Project One courts exist within 5 states, including Louisiana, Wisconsin, Nevada, Kentucky, and 2 courts in Florida. The Wisconsin court was the first Project One initiative, yet the courts spread quickly to other states with juvenile and family judges who led the initiative. Although I've only been doing fieldwork in one site, I do think it's important to recognize the unique political, policy, and cultural contexts in which each of these states operate their juvenile delinquency and dependency systems. I'll return to this point when I discuss the future directions for my project. So to go over again just my research questions, much of the scholarship on crossover youth does focus on these long-term outcomes. But given this reality, I entered the field asking a series of research questions that were informed by my reading of the issues. And once I began doing this exploratory fieldwork, I very quickly realized that my reading of the issues was not going to be enough. And the academic research, the theory, the realities I was seeing, they were somewhat in conflict with one another. So I reformulated my research questions to reflect this point of discovery. And so I won't read these aloud, but these are the research questions that are guiding my research, particularly this last one: to what extent does the court offer access to justice, therapeutic jurisprudence, and restorative justice? And simultaneously, to what extent do specialized justice initiatives of this kind represent a deepening of criminal justice system involvement and reach into the lives of youth and their families? So regarding my methodology, thus far I've done about 53 hours of total exploratory fieldwork, taking place in one field site with multiple courtrooms and courtroom waiting areas, a juvenile detention facility, and a Project One stakeholder meetings. While my findings are not conclusive and are not intended to inform policy just yet, they do color my vision for the future of this project and the key research questions I would like to pursue for this purpose. My preliminary fieldwork illuminated much of the nuance that had not yet been discovered by disciplines like criminology, law and society, and sociology, and which is reflected in some of the preliminary findings that I'd now like to review. So the first of these findings is that many of the interviewed stakeholders often both agree and have conflicting logics about the court and how it's situated in the broader justice system and its history. They also have differing perspectives about the court's implementation, its efficiency, and its ability to live up to its philosophy. So for example, one stakeholder acknowledges the lack of resources, arguing that the resources needed to make this program a success are extremely limited. This person had said, in this particular site location, we under-resource needy populations in a criminal way. It's criminal how we resource in this country. Another stakeholder, however, shed some light on this perspective for me, stating that the policy makes sense, but sometimes we have an issue because we don't always have the appropriate placements. Emergency shelter is not an appropriate long-term placement for a child, but it's the most common. Other stakeholders also shared some agreeing, but at times conflicting sentiments about the availability of resources in carrying out the Project One philosophy. For example, one individual refers to the philosophy as something to strive for, because it aims to provide resources and access to people in need. This person said, we've created a system that works for us, but Project One creates a system that works for families. It's not pure though. The Project One philosophy is difficult to implement, but easy to envision. From this, the court's efficiency for families and youth is seen as a major benefit of the initiative. But a competing logic, however, is presented by a different stakeholder, suggesting that the philosophy is antagonistic to some degree, noting that the philosophy is out of touch with the realities of those accessing the court. This person says that the court is approached from a middle-class perspective, and if you're not behaving according to middle-class standards, then you need help and you need to be fixed. The court helps people to death. We overload these families. The extent to which these somewhat competing logics are true for families and youth, however, is still an empirical question that I plan to explore. The second finding that I'll go over very quickly, because I know I'm running out of time, is that there are reservations about the compromises of due process at the expense of implementing a progressive reform to family law and justice, and how information sharing between stakeholders exacerbates these reservations. So one individual had said, the judge knows a lot about a child and a family. The law says that the judge should not be doing independent investigation and should not be gathering information not provided by lawyers. Defense lawyers might be very worried. There's no knowledge of what's in the judge's electronic binder, and the Project One philosophy is very good, but there are a lot of challenges with getting information into the hands of everyone. So because of this multi-system involvement, sharing information across the actors and institutions with sometimes conflicting roles poses a very particular concern about due process. So this project, while focusing on the particular context of crossover youth and crossover courts, it elucidates the historical and more embedded phenomenon related to a number of social and legal institutions. The ongoing project will continue to employ multiple methodologies, including court observation, interviews with stakeholders, and attendance at Project One meetings. But in addition, I will also be doing interviews with children and their families, experiencing the court to ask critical questions about their experience with the welfare and justice systems, their perceived access to justice, and experiences with therapeutic jurisprudence and restorative justice in these courts. Considering the theoretical framework employed in my work pertaining to state power, intervention, and social inequality, I also intend to incorporate a historical analysis of specialized justice initiatives into my long-term project, particularly the role that I believe white feminism has played in constructing the juvenile and dependency and delinquency systems. By doing so, this will provide a richer context and platform for understanding the lineage of these specialized justice initiatives, their impact on youth and families over time, and the theoretical and ground level consequences of specializing justice for special groups of people. The particular case of crossover youth and families, for purposes of my project, provides insight into the newer specialized initiatives manifesting in the realm of juvenile and family justice. Using an interdisciplinary approach and perspective in this project will allow for a more thorough and critical understanding about the realities of specialized justice initiatives and crossover status. Thank you.